The prosecution has officially rested, and now the pressure shifts instantly. All eyes turn to the defense because they face one of the biggest decisions in any trial. Will the defendant take the stand or stay completely silent?
Worth, would you like me just to tell the jury when they come back in that the state has rested?
Yeah, so that's fine.
Okay, will do. Ms. Lewis, Ms. Nestor, what's the plan?
Ready to go.
Who's defense counsel's first witness?
Can we have just a minute?
Yeah.
We have a couple of options.
Understood.
You don't want to. Your Honor, actually, at this time, the defense intends to rest.
We should probably do that in front of the jury, yes?
Right?
Okay.
I agree.
I just want to make sure you've consulted with your client about this.
Absolutely.
Is now an appropriate time to get a waiver of Ms. Richins' right to testify on the record?
Yes. Yes, you can.
Okay. You've consulted with Ms. Richins about her, or advised Ms. Richins about her right to testify, correct?
At length.
Okay. Ms. Richins, may I ask you 2 direct questions?
The attorneys pause and ask for a moment. You can feel the tension building. Then suddenly, the defense makes its move. They announce they intend to rest without calling the defendant to testify, a decision that could change everything.
Yes.
Do you understand that you have the right to testify at trial?
Yes, I do.
Are you following your attorney's advice and waiving your right to testify at trial?
Yes, I am.
I accept your waiver. I find it's knowing and voluntary.
Yeah.
Okay, thank you. Anything further on the record, Ms. Lewis?
No, Your Honor.
Mr. Bloodworth, how would you propose we proceed from here for the rest of today?
So let me backtrack a little bit on your earlier question. I think I should then rest in front of the jury.
Understood.
The defense can then rest in front of the jury. I think then for the rest of today, and I propose tomorrow, the court recess, and that we begin. The parties can work on jury instructions perhaps today or tomorrow, but then we instruct and close on Monday.
My face is not telegraphing any opinion one way or the other. I'm just waiting for a response.
I don't think we have a problem with that. I thought we were thinking it might make sense to get the jury instruction conference out of the way, and then.
I agree with you. May we do it tomorrow? Give the counsel, both sides, a chance to talk to each other about any additional instructions you think might be necessary, narrow any differences or discuss any differences you have regarding any of those, and we can have that conference tomorrow.
Yeah. Yes, that's fine.
Okay. So we'll talk about scheduling about that. Just want to make sure we're all comfortable with the jury being out in the wild between now and Monday morning. Yes?
Yes.
Yes, sir.
Okay. Okay.
Now comes the critical moment. The judge confirms the defendant understands her rights. She has the constitutional right to testify, but she chooses to waive it, voluntarily and on the record, leaving the jury with unanswered questions.
All right. Are we ready for the jury? Mr. Bloodworth?
Yes, sir.
Ms. Lewis?
Yes, sir.
Okay. Please have a seat as you come in. Have a seat, thank you. Mr. Bloodworth.
Your Honor, the state rests its case.
Very good. Ms. Lewis.
Your Honor, after consulting with our client, the defense rests.
Understood. Thank you. Ladies and gentlemen, there is some legal work that I need to do with counsel in this case to get from here to the next stage. Rather than use your time inefficiently with you in the courtroom, we're going to do the following. We're going to recess for today. You will be on your own in the wild between now and 8:30 a.m. on Monday morning.
As the courtroom shifts towards scheduling and strategy, jury instructions and closing arguments are planned. But beneath it all, the real tension is building. Because silence can speak louder than words. When the jury returns, the defense rests its case, and the outcome now lies entirely in their hands.